Checkpoints is presented by pharmaceutical company GM Pharma.
Dear Ted, thank you for being with us and taking my questions. What did the parliament, Georgian Dreams parliament, adopt today? Is it FARA?
Yes, okay. It's kind of like there's good news and there's bad news, all right? The good news is that they did adopt the US FARA law word for word, verbatim. They even in one paragraph forgot to take out Attorney General, which is from the US version, instead of putting in Corruption Bureau. But yes, they adopted it verbatim, and generally speaking, I think that's good news, and we will talk about that more. The bad news is that they pulled a trick here, because knowing that, so what they have done is they have actually made conditions far worse for Georgian media. In a way, they have given a break to the NGO sector, and they have attacked the media stronger. So the Russian law said that any media organization that had 20% income or financing from a foreign source was a foreign agent. That was the Russian law. That's still there. Well, actually, it's not still there. What's in the new law is an exception for media, like there is in the United States. There are certain special provisions for media. But what they did was they amended at the same time that they adopted the new US-type FARA law. They were like, this is not strong enough on the media. This is a problem. So they amended the broadcasting law to outlaw any foreign financing, any foreign ownership, any foreign economic contributions to Georgian media. And of course, they put in a lot of other tough restrictions that I'm sure you're well aware of. I haven't studied the law in detail, but I've read about it. So
this exemption kind of doesn't make sense then?
It doesn't make any, yes, it doesn't make any sense. In the US law and in the Georgian law that has adopted the US law, it says that any media organization that has 20% foreign ownership is considered a foreign agent only if it actually is an agent. It acts as an agent, okay? That was not, they kept that in the Georgian law, but it's completely nonsense because now they have made amendments to the broadcasting law which say that no media organization can get any foreign financing. So the foreign agents law that they have just passed has a provision on the media which is just nonsense and irrelevant because it is eliminated or vitiated, as we would say, by what they've put in the broadcasting law, which says that media organizations can't get any foreign money at all. So they have considerably tightened the noose on media in Georgia while backing off on the NGOs in this law.
That's an interesting point. What do you mean by backing for NGOs?
Well, it's funny because now we go back to the way that I explained the U.S. Foreign Agents Registration Act when I first started to do interviews on this, however long ago, 2 years ago even, when they first brought it in. So it is the exact text of the U.S. law. The U.S. law contains exceptions from the registration requirement for multiple types of NGOs who were covered by the Russian law. And so I can just run through those real quickly, but it includes academic organizations, religious, religious, educational, and scientific organizations are not covered by this law at all. And this is really good because there was great concern that religious minority organizations in Georgia that, say, the Georgian Orthodox Church doesn't like, were going to be persecuted by this law. Right now, religious organizations are now exempt. Educational and scientific organizations and activities are exempt. Foreign governments that are allies of Georgia are exempt. Now, it's interesting who the Georgian government considers their ally today. Is it Russia? Is it the United States? Is it France? It looks more like Russia. So maybe they'll exempt Russian organizations, Russian-funded organizations, I don't know. Then law firms are exempted from this. So it is actually very helpful. There's a number of organizations that were covered by the current law, humanitarian organizations also, I know that's in here as well. Those will now be exempted.
You are comparing this with the previous Russian law, which covered all these types.
Yes, the previous Russian law did not exempt any kinds of organization. But what is really most important here is that I do not believe that Georgian officials understand what is an agent under U.S. law.
Exactly, that was my question.
Okay.
I mean, how to define agent, because in Georgian it has totally different connotation, and you know.
Correct. So what makes the U.S. law far more limited than these people think it is that it applies only to a person who is under the direct instruction and control of a foreign principal. What that means, you know the word in Georgian, amindo biloba, a power of attorney. It literally means that the principal has given a mindo biloba to another person. You are supposed to do these things for me. Every Georgian knows what a mindo biloba is, a power of attorney. To sell my car, to pick up my car, to clear it through customs, to open a bank account, to do things like that. And an agent who has a mindo biloba like that has what we call a fiduciary responsibility to the principal. That means that he has this high duty of loyalty to carry out only the interests of the foreign principal. Now, the kind of power of attorney or mindo biloba that we're talking about here, as it says in the Georgian law and it says in the American law, because they're the same, that agreement that the agent will act on behalf of the principal, that mindo biloba can be written or unwritten. Okay? Now we know for a mindo biloba to work in Georgia, it has to be written. So we are talking about oral instructions as much as we're talking about written instructions. But oral versus written makes no difference in the content. The content must be that the agent acts in the name of and on behalf of the principal, the person giving the mindo biloba. Takes great care that their interests are served. So to take just any number of simple examples, when Transparency International gets a grant from the National Endowment for Democracy for voter education in Georgia, they are not acting as an agent of the National Endowment for Democracy. They are not carrying out its specific instructions. They are not acting for its interests. They are, in fact, working for the interests of Georgia, Georgian society, democracy in Georgia. Okay? They don't have detailed instructions from NED on everything they are supposed to do to develop democracy. They get a grant for a general purpose. That general purpose is TI's purpose to build democracy in Georgia. It's not NED's self-interest in any particular thing or policy. And this is a distinction that American lawyers and American law, and English law for that matter, have no trouble making between somebody who gets a grant to, I apply for a grant and say, this is what I want to do, and they give me a grant and I go out and do it. I'm doing what I wanted to do, not what the grantor wanted me to do. And any American lawyer understands very clearly the difference between that and if the National Endowment for Democracy gave me a mindo biloba and said, you will act in Georgia as the National Endowment for Democracy, not as TI, but as my alter ego. You will act as the National Endowment for Democracy to carry out specific acts. And, here is a huge book that summarizes
agent.
Yes, that is all of the details of how what an agent means under U.S. law. It's called the Law of Agency and Partnership. And this is a summary. This big book is a summary. It is, the actual law is contained. This is how the common law works. So is Georgia incorporating the entire Anglo-American concept of agency, which means a person acting on a written or oral mindo biloba to act in the name of the foreign person. They're not doing it. TI doesn't do that. GILA doesn't do that. None of these organizations do it. The only example you could find, if the National Endowment for Democracy opened a filiale, a representative office in Georgia, to carry out activities on behalf of the National Endowment for Democracy, that would be an agency relationship.
But TI Georgia doesn't qualify as TI's filiale in Georgia.
Of course, as NEDs, of course not. No, they don't. They're not in that legal form. They are an independent organization. So I would actually argue that none of the NGOs that they are targeting and that they have been complaining about qualifies as an agent under the U.S. Foreign Agents Registration Act, which is now the Georgian Foreign Agents Registration Act. None of them qualify for it. Who would probably qualify are people who are acting on behalf of Russian interests in Georgia and are acting on Russian instructions. Those are the people who would qualify as agents under U.S. concept of agency law.
Do we need something like that book or whatever that book represents in Georgia?
Absolutely, absolutely, because what they're going to do with this law is they're going to say, oh, well, an agent is whatever I think is an agent. They got money from NED, that makes them an agent. No, it doesn't. Not under U.S. law, not under the law that you adopted, okay? So if they were serious about this, which I don't think they are, but if they were serious about it and they wanted to do it exactly the way it's done in the United States, you would not only copy-paste the U.S. law, you have to incorporate into Georgian law the American concept of agency, of an agent, for that law to be the same. Now, they could do it by commentary to the law, they can do it however they want to, but they need to explain that an agent is not determined by whether they get money or a grant or anything else. It's determined by whether they have a contract to act as an alter ego, a representative of that foreign principle, the way that agent is described in the United States.
Mm-hmm, mm-hmm. So the fears whether or not FARA in Georgia, this new legislation, could lead to unlimited government inspections, establishing harsh penalties for violations. This is still in place with this piece of legislation.
Yes, it is, because they don't know or they don't want to interpret it and apply it the same way it is interpreted and applied in the United States. And again, that's not just about words, that's about hundreds of years of legal definition of what is an agent.
Can we say that FARA is a repackaged Russian law, or is it FARA?
No, it's FARA. It's FARA, but what I would call it is a trick. It was a trick in order to impose even worse restrictions on Georgian media. And clearly the two things went together. They took, in the amendment to the broadcasting law, they took the exact definition of a foreign principle from the Russian law and put it into the broadcasting law. It's the same. So literally the things that they wanted to not only keep from their previous Russian law, the Foreign Agents Law, but they wanted to make even worse, they put into the broadcasting law and applied it against media. So one thing is, it was a trick. It was a trick meant to say, oh, we're liberalizing the law about foreign agents, but then they choked it much tighter on the Georgian media when it comes to getting any foreign sources of funding. And the second way it is a trick is that they know that they will apply this U.S. law and the word agent the way they want to, not the way that it is defined under U.S. law, and which is an inherent characteristic of it in the United States.
So at this point, what is the biggest threat or risk coming from Georgian version of FARA?
Honestly, my impression is that the risk is reduced. And I believe the risk is reduced for NGOs for the reasons that I mentioned before, which is that number one, there's the exceptions which now means that a lot of organizations that had to register before will not have to register this time, the academic, scholastic, religious, artistic. Secondly, if the law is actually properly applied, none of these NGOs are agents. None of them would have to register under this law because none of them fit the American definition of an agent, okay? So I would be happy, and I'm looking forward to seeing the court cases where Georgian lawyers are going to go into court and argue, you, prosecutor, do not understand what an agent is because this organization is not an agent under that law. And let me bring in, since you use the American law, let me bring in the American commentary, let me bring in all of the American common law on what is an agent. They do the same. A lot of laws in Georgia were German background, and I have seen many times Georgian lawyers argue in Georgian cases according to the German understanding and German interpretation of laws that Georgia adopted that were based on German precedent. So first thing is the exemptions. The second thing is that none of these organizations are actually agents. A third one is, at this point that I noticed, which is that actually this law authorizes any of these organizations to register under the Lobbying Act, the Georgian Lobbying Act of 1998, which is not nearly as strict as this law, and that satisfies the requirements of this law. Okay, so they left a loophole from the American law in this law that I would consider using if I was in a bad spot. Also, it seems they've eliminated the monitoring function. Before they there was this whole supervision and all of that. That's gone. So unless they have kept it, unless they are not repealing that part of the Russian law, and that's staying on the books, then the supervision is reduced. The documentation requirements, I think, are less. The documentation requirements for the Russian law were terrible. I talked to a lot of people who had to try to comply with those requirements, and they were a disaster. They were extremely burdensome, extremely complicated. They were hard for organizations who wanted to comply with the Russian law. They were very hard even for them to comply with. I have some feeling here, to be honest with you, maybe it's just a fantasy, that the Georgian authorities were like, okay, not many people are registering under this law. One reason why they're not registering is because it's incredibly burdensome. The staff of the public registry are overwhelmed and overworked trying to handle these registrations that's supposed to happen. So I think it's entirely possible that the Georgian government saw that the Russian law that they had enacted was not being complied with and was not working. So instead they adopted something that was easier and easier for them to apply. Okay, they didn't want the media to get off the hook, so they made amendments to the broadcasting law that are worse than what was in the Russian law. And then what they adopted for everybody else gives them some mechanism of control, supervision, registration requirement. They can abuse it and use it against people in the wrong way. So it's still a weapon for them, and it's a tool for them. But as a lawyer, I have to look at it, and comparing it to the previous one, it is not as bad as the previous one. They will abuse it, I am sure, because that's the way they are. But on paper, it is not as bad as what was there before.
Well, let me read some of the assessments. For example, Human Rights Watch. Human Rights Watch's assessment was that it could spell end of Georgia's independent civil society. Do you think it can be abused to these?
If it was heavily, yes. Yes, because we know, look, yeah. If it was heavily abused, it can do great damage. And the thing is that, unfortunately, we know that the Georgian prosecutor and the Georgian courts have no principles. They do not follow valid methods of legal interpretation and application. If you followed valid methods of legal interpretation and application and enforcement, this law is not dangerous to the civil society sector. It's not. If it was properly interpreted and applied, but it won't be. And again, I speak from personal experience as somebody who went through a Georgian court hearing for petty hooliganism, and it was, of course, a complete joke. I mean, you know, and we all know that that's the way that the Georgian courts work. So
does Georgia need this type of piece of legislation?
The reason, and that's a good question, and I'll go back to something I said 2 years ago when we did interviews on this. The U.S. decided it needed this piece of legislation in 1940 when it was being undermined by Nazi and Bolshevik agents who were hiring lobby firms in Washington, D.C. secretly to influence U.S. public opinion and the U.S. government. So this law arose out of the national security threat to the United States in 1940 on the eve of the U.S. going into World War II because of both the Bolsheviks and the Nazis. And as I've mentioned before, it has always been applied in the United States that way, okay? The prosecutors use this law not to go after NGOs or companies or whatever. They use it to go after people they already suspect of money laundering, people they already suspect of bribery, people that they, and especially from foreign enemy powers. It's been applied against Chinese interests. It's been applied against Iranian interests, Pakistan, which is sometimes an ally of the United States or not. So does Georgia need this law? Well, my position would be, yeah, Georgia needs it to find Russian agents, okay? Georgia could have a law meant to expose Russian agents, because the real danger to Georgia's independence and sovereignty today, as I think the majority of this country well knows, and it has been for a long time, has been from Russia. Russian infiltration inside the government, Russian activities that go on in society.
To have some kind of country filter to it. Right?
Yes, well, I mean, in effect, you know, again, the U.S. is a different type of legal system. A lot of things are left to the discretion of prosecutors and to bureaucrats, and we've always trusted their independence and their judgment. Now, that is changing in the United States right now, unfortunately, but Georgia doesn't have that kind of culture and background, so they get a law like this and the prosecutor will tend to use it in whatever way he can.
No,
but
Georgia has sanctioned
judges are sanctioned, you know. So, you know, do they need it? Well, I mean, they already get financial statements and tax filings from all of the NGOs, so they already know that the NGOs have foreign sources of money, right, which is in their tax filings and in their financial statements. I took time to look at the financial statements of a lot of the Georgian major NGOs. They're on their websites. They identify where the money comes from. There's no secret there. And are they doing something harmful to Georgian society? Well, if you're against democracy, they are. If you're against rule of law, they are. But if you support democracy, you support rule of law, you support fair elections, then these organizations are not doing something against Georgia's interest. They're doing something, for Georgia's interest.
Do you see how FARA can be implemented in Georgia? I mean, do you see judges that understand what that means?
No.
Do you see whose discretion it should be
no,
to take those judgments that you just mentioned to
No,
me?
exactly. No. This is a legal system that is not set up and prepared to fairly apply a law like this. Because beginning with the fact that they're going to say an agent just means somebody who has a relationship with somebody else. That's how they see an agent, just in this broad idea, oh, TI gets money from the National Endowment for Democracy, therefore they're agent. No. Under American law, that absolutely does not make them an agent. They've got to be acting on specific instructions and in their name. What it means is that, for example, if TI were to sign a contract in Georgia, it would have to sign it as in ED, not as TI. That's an agent. Mm-hmm. Again, like a Mindu Biloba. Mm-hmm. If I give you a Mindu Biloba, you're not acting as Elene Kvanchilashvili, you're acting as Ted Jonas. Okay, and that's not what TI does or GILA does or ISFED or any of these organizations. They get grants for general purposes that they proposed. It's their interest, their programs, and they get money from countries and funds that want to support that kind of activity.
What about companies, businesses? Are they covered by FARA or are they exempted from FARA?
No, they would be covered, but business revenue is exempted. An agent can be a law firm or a lobbying firm in the United States is a business and a legal entity and might have to register under FARA. If you look at agent, it means any person. Yeah, and a person is individual, partnership, association, corporation, organization. Yeah, so the agent can be a business as well.
So at some point it is broader than what was the Russian law?
Yes, that was always true, that the Russian law was narrower in how it defined if I remember correctly, it was narrower in how it defined the entities or persons that can be agents. It did not include businesses,
No.
I think.
Right.
It excluded businesses. You're right. This does not exclude businesses, okay? But again, you got to look at, this law doesn't care about money. The U.S. FARA law doesn't really care about money, and that means now the Georgian law doesn't, okay? So let's take a Georgian business, you know, I don't know, let's take Wissall. Wissall, Georgian business. Wissall, if Wissall receives investment and money from a foreign investor, receives loans from foreign banks, let's say it gets loaded with money from foreigners, it's not an agent. Why? Because it is not acting on their mindu biloba. It is not acting as their alter ego. It is not acting on their behalf. Now, if Wissall doesn't get a penny of money, but a gasoline supplier in the United States says, Wissall, we want you guys to be our representative in Georgia. And we want you to lobby the Georgian government to get them to change the chemical requirements of benzene so that our product will sell in Georgia. That is an agency relationship, and that is a foreign agency relationship. And that's exactly the kind of company that would have to register under US law. I'm registered as a foreign agent in the United States for a Georgian company, the Anaklia Development Consortium, okay? I have an agreement with, I'm a board member, okay, but I have an oral agreement in effect that sometimes I go to Washington, talk to members of Congress, talk to White House officials, I've done it before, and advocate Anaklia's interest, okay? I can't walk into one of those meetings and say bad things about Anaklia. That would violate my fiduciary duty to Anaklia as an agent. What makes me an agent is I go in there as their advocate. I go in there as their representative, okay? So again, talking about businesses, a Georgian business getting money from a foreign investor, nothing to do with this law, nothing whatsoever. But if a Georgian business doesn't even get any money, but agrees with an American business that they will advocate certain regulatory or legal changes in Georgian society that will benefit that American company, that is a foreign agent. And that has to register under this law.
And this is exactly the definition that we don't have.
Correct. There's only a very general definition of agent. Well, see, they use the word agent. They don't define agent. They don't define agent because an agent is understood according to 600 years of American and British common law. That's why they don't define it in this law. They simply say an agent of a foreign principal is any person who acts as an agent. Who acts as an agent, a representative, an employee, a servant, acts at the order, request, or under the direction or control of a foreign principal. That's the Georgian law. I'm reading you from the translation of the Georgian law. Also, any person whose activities are directly or indirectly supervised, directed, controlled, financed, and subsidized in whole or in part by a foreign principal, or through any person, and. So he's got to be an agent, and he has to engage in political activities in the interest of the foreign principal. That's in the law. Acts within Georgia as a public relations counsel or publicity agent for the foreign principal. Solicits, collects loans and money for the foreign principal. Represents the interest of the foreign principal before an agency or official of the government. You see? So if Transparency International is not an agent of NED, which I posit it is not, for all the reasons that I've told you, it is not an agent of NED, and if it does not do these things, if all it does is public education, They're not under this law at all. They could get their whole budget from the NED, and they're not NED's agents under this new law. So there is an enormous amount of room for lawyers to defend any Georgian NGOs that get accused under this law. Legal defenses.
Yeah, but that's exactly why it's not okay for Georgia, Russia, that type of countries to have
contact. Yes. You copy paste the American law, and it is not the American law at all. It is a far, far more dangerous instrument if you don't have the narrow definition of an agent as somebody who basically has a mindu biloba to act on your behalf.
Later, Georgian Dream initiated a new bill that mandates government approval for receiving foreign grants, necessitating consent from the government or an authorized representative. Accepting a grant issued without such approval will be prohibited and will result in liability. The relevant amendments will be incorporated into the law on grants initiated during the Bureau session. In light of the amendments, the government will have 10 days to express its consent to the disbursement of a grant. Appeals against the government's decisions will not halt enforcement. The Anti-Corruption Bureau will oversee the issuance and receipt of unauthorized grants, with recipients facing fines equal to double the amount of the grants received. Certain exceptions are established within the initiative. The mandatory government approval requirement will not apply to grants from international sports associations, federations and committees, individual scholarships for secondary and higher education abroad, or grants from international organizations operating in Georgia. We called Ted Jonas for a short follow-up. So thank you for this follow-up opportunity. You told me about a week ago that FARA law has loosened the loop on NGOs. Do you think the same after GD introducing the law on foreign grants?
Yeah, no, of course. And in fact, what I said last week was that the U.S. FARA law, which Georgia has now adopted, was, in the four corners of the law, a great improvement over the Russian law, but they had pulled a trick by at the same time making amendments to the broadcasting law, the media law, which made things much worse for the media than they were even under the Russian law. Now they have done the same thing to NGOs with what is effectively a complete political block on foreign grants to Georgian NGOs. So it really makes you wonder, why did they even bother to change the law and bring in the U.S. FARA? Because in fact, they have now made, through amendments to other laws, they have made the restrictions on Georgian NGOs far, far worse than they were before. So it means that this use of U.S. FARA was a complete trick, a farce, a lie that they have perpetrated on the Georgian public. The worsening of conditions now for NGOs under these amendments to the NGO law is so obvious that no Georgian and no foreign partner can be convinced that they have liberalized their laws in any way. In fact, they have made them much worse.
And this is also a tougher regulation on online media as well, because you focused in our previous interview on the law on broadcasting, which mainly means TV media. But now with these new regulations, it also affects online media, right? Because grants were the lifeline of these organizations.
Yes, no doubt. I haven't had a chance to look at these amendments yet. I've only seen the news stories, so I don't know much about the details, but I have seen the news stories. I've seen the reactions of people in Georgia, and I think it's very plain. I mean, they are imposing government political approval of any foreign grants to Georgian NGOs. That's an outrageous restriction on free speech, and again, is an even tighter, far stronger. It's a block. It's an obstacle. You'll have some political official, bureaucrat, maybe senior GD person deciding what grants Georgian organizations can get.
GD says that this law targets donors and not NGOs or online media or anything that you have mentioned, since donors need to get the consent from the government and not NGOs per se. I mean, what type of argument is that?
That's ridiculous. That's what we would call in English semantics or sophistry, which means that you make an argument with words that has no meaning and substance. Of course, it's the same. It's not against the donors. I mean, it's far more against the recipients. It's far more to the disadvantage of the recipients of the grants than it is to the ones giving it.
Yes, and what does this mean for an average citizen of Georgia as well, Ted? Because we know that these NGOs with these grants, for example, helped people with, free services, free court services and stuff like that. I mean, does this mean that everything will be restricted by law?
Yes, I mean, it has a negative. It is restricting the information that people can get. So freedom of information is restricted. It can easily have a negative impact on the delivery of health and humanitarian services that have been provided by NGOs and with the assistance of foreign grants. If the government decides that they don't like the donor or they don't like the recipient. So people's access to information, people's access to or their freedom to practice religion, again, because I'm quite sure that grants to religions and religious denominations that are disfavored by the government or the Orthodox Church are going to be obstructed. Services that they could get. So this is just one more step in the authoritarian chokehold on Georgian society. People may not like to hear this in the Georgian opposition, but I'm speaking to you from the United States, and we're facing the same problem here, which is that the government is becoming increasingly authoritarian. And this, Georgia had a big jump on the United States. It had been doing that for a longer period. But what is happening is a closing of free space, a closing of freedom of action, of information, an increasing monopoly on information by the authorities. That's what they're trying to do. And so really we are, as human beings, we are facing citizens, whether of Georgia or of the United States, we're facing a struggle to assert our rights and our freedom in many places in the world today, and this is another example.
And my last question, and thank you so much for your time. What is FARA needed for then? Is it just for name calling, for using the agent without its proper definition, which we have already discussed previously?
It's not needed for anything. I mean, because as you and I discussed in our last interview, all the organizations that they're targeting do not qualify as agents under U.S. FARA. Okay, so the law, yeah. So they don't even. Most of these organizations, again, like TI or ISFED or GILA, they shouldn't even have to register under the Georgian FARA because they are not agents of any foreign actor according to the legal definition of an agent. I almost wonder, honestly, and this is almost what it looks like, is that after they enacted the U.S. FARA in Georgia, then they suddenly realized that it doesn't serve their purposes. It doesn't actually do what they want to do. It is not a sufficiently repressive instrument against the organizations that they hate. So they were like, oh, gee, this was a mistake. You know, this doesn't accomplish anything for us. So now they've said, okay, let's do what we need to do, which is choke off the funding and restrict these organizations as much as possible through amendments to other laws.
Thank you so much, Ted. Thank you for your time.
Yes, thank you, Elene.
The Checkpoints is presented by pharmaceutical company GM Pharma.